Hi everyone, it's Grant Abbott speaking, and thank you for coming to our normal Thursday sessions where we generally launch a new document and go into the ins and outs of it. And we have got, I was having a chat with Ashley, our COO, the other day. We have now more than 75 documents on the platform, and we've got some pretty big automations there, including the Moat, which does your EPOA, either establish or upgrade to leading member, SMSF, and also corporate trustee, or you can just go to a normal LightYear docs, SMSF and corporate trustee. Does your SMSF will, and we will be releasing a binding death benefit of a nomination next week. And then does your wills and testamentary trust. So that's all in one line, and we will look at that a little bit later on because it sort of correlates with where we're going today. So in the past, you've been to one of my presentations, or you've been to anyone's presentation for that matter, and I'll talk about a strategy, and you'll go back and say, okay, well, that's a great strategy, but how do I do it? So the first step in our process, and this has been a matter of really I suppose the software we use, it's called robotic processing automation. It's effectively taking a process or system and automating it as best as possible, so that it really puts the person out of work, the one who normally does that role. And what we're doing, or what we're achieving through this process, is basically to put me out of work, or effectively still have me as the head person in the business, but at the end of the day, all my intellectual capital, all my IP is there for you guys to use, particularly the licensees and everyone who's on an LYD strategist or LYD firm. So we've managed to put on 75 documents, a whole lot of strategy automations. So now the process and some of those larger ones have been mapped. So we've got a flow chart that we do for each strategy. We then build the documents in that strategy, and then that now means that whole strategy is completed. And if we have a look at the Moat, that's a really comprehensive estate planning and succession package. So we've done that, but that's okay. So that's still one step. The next step then is, of course, the client engagement. Now, the problem where we are at the moment is that as planners and also accountants and SMSF advisors, we just don't have the time to get clients in, and more importantly, talk to them and motivate them about anything. Because one is it's a good process, but having to sell a process to a client can be pretty disarming. So the best way of doing that is to use client engagement tools, and that can be, for example, I know some people use Facebook, some people use emails. If you know us, we love using our emails. We find it's a great tool. We have good, probably 50-60% open rates, which is great, and certainly great click through. So it works for us. But then there's, still for a demographic that you might be looking at, and we're looking at, because we're dealing business to business, we don't deal directly with clients. But for a lot of the stuff that we're going down the track for, the good old letter marked private and confidential works an absolute treat, because people just don't get letters anymore. It's a very cost-effective and personalised way of getting engagement with a client. Of course, you can do seminars, which is another way of doing it. But what we're doing is we're now starting to turn our attention to that client engagement piece. We've built our documentation, we've built our strategies. We've still got a whole lot of new documents coming through. But what we want to do is now start to turn our attention to give you guys our tools or engagement letters, data collection, so that when a client completes these, sends it back to you, you work out your pricing, your fee, and then it's very easy to take that data and put it into obviously the system that we have, into the LightYear Doc strategy system. And that means that then that time spent is really compressed, that you may not, you probably get the client in for a meeting at the end, but the actual time spent to deliver can be quite significant. So that's pretty good. And actually, that's thanks for that, Roy. Silly me, I haven't thought about the Australian Post side of things. He's got letters take a long time for people to receive. Well, I also like the idea, we noticed letters can take up to 3 weeks for delivery. So that's a good one. In fact, Roy, we can send both an email and a personalised letter. So if there is a bit of a time frame, it's not a bad idea to do that, because one is they might look at it and you can tell whether it's open or not. And then as a follow-up, we've then got the letter itself. So that's a pretty big one. And of course, we just want to keep on having this process going down the track. And we're all in there living and learning ourselves. Now, the issue that I find is that you guys are really good at face-to-face meetings, get the whiteboard out, get people excited and all that. So that appointment that you get, generally that will close them on the actual process or the strategy. So most of you don't have any problems with that. So your discussion or your presentation skills around that area is really good. Now, when it comes to producing copy for client letters, etc., some of you are very good, and I'm sure guys like Roy, if you've been doing that, you're very good at doing copy. But from a lot I've seen, most people don't do it because they don't know how to do it, or they don't know how to drag that copy out. Me, on the other hand, I've written, I write for a living virtually. So, I wrote this presentation maybe half an hour ago. So I'm good at writing. I know how to get to the point. And really, I'm writing these letters for your purpose, but as if they were for clients of mine, if I did have any clients. So the purpose there is to really get the client engaged, promote the various product or service, and then motivate the reader and take them to a call to action. Now, we can there's two ways of doing it. We can send newsletters out with just simple, this is information. Better is a well-directed letter that has a call to action at the end, which you're going to see. So I'm going to show you a couple of the ones that you'll be able to, I want you to get a review of them. We'll go through them and I'll give you a bit of an endpoint. At the end of the day, as I said, that it's not for everyone. So some people like to watch a video, some people will like an email, some people will write a letter. So if we can do it each and every which way, the whole idea is at some point in time, if they get that aha moment, they get motivated. If the issue is important to them, then they'll book an appointment. And then once they book an appointment, then it's essentially, it's up to you guys, because again, you're really good at that presentation side. So from my perspective, as you're going to see, that the letter must be personal and it has to be a topic that's important to them. So, for example, if I receive a letter from my accountant that my BAS or or that I have to pay corporate compliance fees for ASIC, I generally don't even look at that sort of stuff. I've got all these letters on my desk from NAB that, I just it's not interesting for me. I should take more aware of my finances, but I've got better fish to fry and better things to do that are more important to me. Particularly at the moment, I spent last week in Adelaide. My mother's gone downhill significantly in the last 2 to 3 months, and we're getting an ACAT and then putting her in a home. So we've got a place in the home, we've got an ACAT. Once we do the ACAT, then I've got to go and clean out the whole house, sell the house, and that's important. That's a family thing. At the same time, then my daughter's going to school again. Anyway, that's just family. So family is important to me. So a lot of the stuff that we'll be looking at when we're doing an SMSF will, where we're doing a will or an EPOA, these are things that are important to the clients. Doing compliance is not, you guys might think it's important to them, but I can tell you, I've never seen a client on their deathbed saying, I wish I'd done more compliance. But I can tell you every one of the clients that you have is on their deathbed, they would love to have their family around them. And maybe you become their trusted advisor, so they'd love to have you in the room as well. For the older brigade, as I said, a private and confidential letter is the best way, because I know with my mum, as soon as she hears that, that little motorbike going past and the postie's been her little ears, prick up and, Grant, can you go out and check the letterbox? for most of the younger guys, we would never check the letterbox because we know it's always got a bill in it or whatever. But mum still loves that sort of process. So generally, our best clients who are going to be doing SMSF wills, EPOAs, and all that are people who do like letters. But I do again, we need to make sure that effectively it does take, it's fairly quick to deliver. Maybe even for some of your more important ones, do it by express paid post, or even a registered letter is not a bad idea. I would always, not a bad process, email, letter, then follow-up phone call. You're just simply making sure they've received a letter, have they got any questions, and would they like to make an appointment. Sometimes, particularly when we get down to wills and all that, and this will probably be more of the something you'll go, for example, oh no, my lawyer does all that for me. But then if they're like my mum, it hasn't been done for 10 years. And what I saw her lawyer do in terms of my father's advanced healthcare directive and EPOA was pretty dismal. So that we need to get over that stage and just, I'll explain a little bit further. But generally, you guys know all of your clients' personal picture. The lawyer just has that little sliver in time, and really that doesn't really work there for them. I'm not disparaging lawyers, but lawyers are transactional. They don't build relationships. You might have seen. In fact, there's this funny little article. I'll just put it up here. Where is it? There we go. So this is from the Australian lawyer, Australasian lawyer. So it's not as the lighter side, lawyers as trustworthy as prostitutes. And I don't think that's a bad thing. Where they come from is they've done this analysis here. And you can see a lawyer and a prostitute. Now, a lawyer is obviously extremely competent, but when it comes down to warmth, lawyers generally don't have any warmth. And again, this is not me. This is when we have a look at the chart. And this was, again, it was basically over in the US. But the social side of things is that the warmth, the lack of warmth means that they're less trustworthy. So even though a lawyer knows what they're doing, they generally don't have that warmth, and then people don't perceive them as trustworthy. Anyway, that's what the argument was there. So I thought that's quite interesting, but it again goes to the process that unlike most of you who do have ongoing relationships with your clients, the lawyer only comes in once for a very short period of time and then moves out again out of their life. And generally, particularly more often, we want to see lawyers as least as possible because it's always a stultifying experience. But anyway, that's neither here nor there. So what I want to do is, the LightYear Docs site. So the one that I love the most, and we've had a lot of people ordering that. So that's our comprehensive estate planning package. I'll just go in there pretty quickly. So let me just go that. I was working on it a little bit later on. There we go. So in fact, I might even take it up a bit further so you can see. So Abbott-Family, again, just a bit of insight. If I try to start the document there, it's not going to go anywhere. I need to get the green. So I always do backspace, see the green, click on the green, and then we can start. So I can build the moat here. I'm not going to spend a lot of time and build it for you. I just want to show you what we've got here. So let's say we're building the moat, and that's for the Jones family. Now, if you're on our service, we offer white labeling. So just do support at lightyeardocs.com.au. So for those who are LYD firm strategists or licenses, then you have the ability to have all your documents white labeled. Plus, everyone gets a vault. So there's never going to be any lost documents again. Now, alternatively, if you just want to use the Abbott Morley, the legal firm's logo, you just go AM001. Or if you don't want any, then just put that in there. So the reason we do that is so that the client doesn't get a LightYear Docs logo on there. So we started off doing that, but then we sort of bin that because we don't want them to go online and see the documents. So that's a document setup. So it's now in the Abbott-Family vault, and it's shown as the Moat, the Jones family, and it's got the AM001 tag. So now the documents that we've got here, these are all the documents that we've got. So what I can do there is I can do an EPOA. Now, importantly for our client, I'm going to show you the 3 letters. In fact, we've got a few letters there that we can use. We can do the whole thing at once. Now, what I like to do is get this common party. So we get if we're doing wills and testamentary trusts, you get the names of all their children, you get the names of their companies as trustees, their SMSFs and their family trusts. You get that whole thing together, including your name as well as the advisor in question, because that comes up in wills and also SMSF wills. So we put that all into the company, into these common parties. And that means that if it appears more than once in the document, it's just going to save you time. So it actually splits time. So what we can do is, we're not going to go and do all of this for the client. I've built this as a system to enable you to have the Moat for a client. Now, with that, you can build their EPOA. So, for example, let's say they're in Queensland. You can do an establishment to a leading member. Look, you know how I feel about leading members, but really that's pretty important. We can get a constitution upgrade for a leading member. We can do an upgrade of the deed as well. I would probably do it in this order. So everything is specific. So we do the EPOA that covers us for superannuation. Then we would go and do an upgrade of the deeds. We then do an SMSF will, which is really just a BDBN, it's just a bit more fancy. And then we would go through and do the will. So you can see all those documents are sitting on the left there. And it doesn't take us long to go through, but for this one, I built it, I put all the common parties in, and then what I've done is I'm not going through any of these. So all I'm doing is I'm using this system to simply build an enduring power of attorney. Alternatively, I could go in and I could go into LightYear Docs, and I could simply go into do EPOA, which is maybe it's not there because I should use the Queen's English there on chat. So I could do an enduring power of attorney separately as Queensland. Then I could do upgrades. Then I could do the will, SMSF will or BDBN. Then I could do the will as well. So I'm in and out of this system all the time. So generally that's not a bad thing, but you can see through the process of automation, we're able to use this as we want. So I put all the common parties in, which is useful, and I start off with the enduring power of attorney. So for that process, because you don't want to overwhelm your client, you want to get them into a pretty good space. So what we can do is we go to the support center, which is you need to log in to get to the support center. So if I'm logged out, then I can't get to the support center. If I'm logged in, I can get to the support center. Now in the support center, I'll just take us back so you have a look. There's the LightYear Docs, getting started, strategy info advice toolkits, and webinars and training videos. So for example, this video now will pop up into the training videos at a later stage. And I can tell you we do lots and lots of videos. For example, here, if I have a look at my channel, so if you have a look at the sort of information, this is my 3rd webinar this week. So you really don't need to get CPD or information anywhere else. And look, you see you've got basic ones, how to set up a self-managed superannuation. So these are just some of the videos that we've done over the last 5 or 6 months. So look how many videos that we've got there. So from that perspective, it's a continual process for us. No one else produces the amount of information, which is beneficial for you, because when you get to the support centre, you know that like people come and say, Grant, I want to do this, this, this. I say, look, go and watch that video, because you've been on it before, and then you can cover it off. Now, what we're doing is we're now spending a lot more time in our business to help facilitate and build tools for you. And I've got some really exciting stuff coming down the track. So remember we've had a look before on the investment strategy letter. So that's basically sitting in there. If you want to do a deed upgrade letter, that's basically sitting in there as well. If you want to do a leading member data capture or client engagement letter, that's sitting there. That's for the leading member. Remember when we had a look at the moat, that would be, for example, if we're telling our clients we want to go through the process of moving to a leading member. And I always use the leading member as a concept around bloodline and also lineage planning. Anyway, let's go to here. So these are two brand new ones. I've still got to do the SMSF will. I've got the fact find there, but I need to do a letter for that. So the way I want to work on today, I'm going to take you through these letters. I'll take you through the fact find. And then if you would like to have input, so these will now drop off the site after this session. If you'd like to have input and review the letter and come back with your ideas and suggestions, because this is all of us working together as a group, please feel free to just contact us at support@lightyeardocs.com.au. Now, importantly, when you do that, or alternatively, if you're on the site, you can see where it says this support button here. Always use that. Put your name, your email address, and how can we help you if there's ever an issue. Because what happens, that pops up in our little support system here. So I got Michael Goot can't get into the webinar. I don't know why that's the case. Anyway, so what I'll answer for that. So what I do is just simply say, Michael will send you the recording in a couple of hours. Sorry about that. So then what I do is, the important thing about that is it's a great way, instead of contacting us through email, by doing that through support or on the support, what happens, it comes through us and we're continually watching it. So let's have a look at the enduring power of attorney. Again, if you'd like to place comment on it, please contact us at support@lightyeardocs.com.au. We'll send you the letter, and then if you could just mark it up with your comments, it'd be great. So it's obviously it's a Word letter, and the reason we do that is so that you can, oh, there you go, look, SMSF Death Benefits Trustee, that's pretty exciting, isn't it? So that's another document that's coming down the track as part of our estate planning suite. So I'll just open this up a little bit wide so you can see it. So this is for you guys. So I'll just do the first one and then it all follows. Okay, so this is your SMSF Enduring Power of Attorney Indemnity Letter. Probably not so much indemnity anymore, but so this is not an advice document. So it's just simply a letter informing the client about EPOA, so on and so forth. This letter has been designed to encourage clients to review and update their enduring powers of attorney to specifically cater to superannuation trusteeship. This may include a complete EPOA over health and finances, but more importantly, focus on the person who may take over as the member's trustee or director of the fund's corporate trustee in the event of incapacity or choice by the member to no longer take on the legal responsibility of trustee. So where a member becomes incapacitated, doesn't have an EPOA, trusteeship cannot pass unless the court appoints an LPR, but that usually takes 6 months. So again, what we want to do is have a look through this process. And here's a letter for you. You put it on your letterhead, so on and so forth, your name, your client's name, and the importance of an SMSF Enduring Power of Attorney for your fund in addition to a normal EPOA. So we're writing to all our SMSF clients on the importance of having, firstly, an enduring power of attorney in the event something happens to you, so someone can take over your financial decision-making. Secondly, to act as a trustee on your behalf well, there you go, there's a typo there, in the SMSF, you're no longer legally able to perform this role. Alternatively, you no longer wish to act as trustee or director of the trustee company. You may not be aware that many standard EPOAs may only apply to financial and property matters if you suffer legal incapacity and may not be applicable to the management of your SMSF. So this is primarily directed for SMSFs. I may do one if there's a need from you guys, which is not an SMSF, just an ordinary EPOA. When it comes to managing your SMSF, the EPOA needs to act as either a direct trustee or as a director of the trustee company on your behalf. This may occur when you suffer legal incapacity. However, it may also occur when you decide to hand this role over to someone, that is your attorney. To solve this dilemma, it is advisable to have a separate EPO specific to the fund trustee and corporate trustee constitution. And then we just simply go through the trustee requirements. Exception for non-trustee members. So in real life, there's certain members who shouldn't be trustees of the fund. Fund members are living overseas. Fund members have dementia, early onset Alzheimer's, whose cognitive abilities are impaired. Or this is a really good one. Fund members who do not want to take on the legal responsibility acting as a trustee of a SMSF. So that might be mum and dad. Mum just simply doesn't want to do that. In these situations, these people need to appoint an LPR, a specific SMSF EPOA, to act as trustee or director of the company, trustee on their behalf. So a member of SMSF is allowed to nominate a replacement or substitute trustee or director of the fund's corporate trustee. This person may not even be a member of the fund to act as their enduring power of attorney. The enduring power of attorney needs to specifically state it provides the attorney with the power to become a replacement trustee and from a date when the member seeks to no longer act as a trustee. So as your SMSF advisor, we strongly remember that together we undertake a simple 4-step. Review any current EPOA. Well, that's a nice thing, but it's irrelevant because the new EPO will basically take over. Update or create an EPO with specific SMSF replacement trustee rules. So you just got to be very careful that you may have an EPOA, but quite a lot of trustees don't allow the EPO to become a replacement trustee. More importantly, you also find that the constitution of any trustee company also is probably lacking in that regard. So again, it's not a bad idea to go through and work out a pricing for actually not only doing the EPOA, but also upgrading as well. You can put that in. Look, if you want, you can put in there update or create as trustee rules. You can put in the cost is going to be $650. Remember, if you're on unlimited, you're paying on a monthly basis anyway, so you can add extra documents in for virtually no cost or for little extra cost. So review the fund's trustee, ensure its ability, blah, blah. We can provide the above 4-step review for members of the fund and if need be, update the fund's deed for no cost if it falls short. I put $350, but that I just simply picked that up out of the investment strategy. We could put in there, if you want, $650. Now that's not too bad because most EPOAs from a lawyer will cost $750 anyway. So here they're getting the EPOA plus the deed upgrades as well. We believe it's important to complete this task immediately provide stability, certainty, and security if something happens to a member of the fund. So this is pretty strong. You've got here, look, that they can either tick this box, they want to go ahead, or they don't, but they're basically disclaiming all liability. So that's not a bad one. You see them tending to drop that off. Now, what we do here is we now go to the data capture. So this is the new thing from us, and really I'd like to have your feedback here. But all of these fields essentially feed into the process here. So if I take you up to our moat, I've only ticked Queensland, the common party. So I have to work in there the principal. Now, I haven't got any common parties there. If it was common party, I'll be able to do it really quickly. So I've got to have the name of the individual. I've got their attorney. I've then got their personal and health matters, so on and so forth. So I can have joint attorneys and I can have successive attorneys. So going back to the letter, we've got who is to be your attorney. This may be held jointly by one or more persons. So just put in the names of the people. In the event that none of your attorneys hold capacity or are alive, who is to be your second attorney? This may be held jointly by one or more persons. If you don't want a second line of attorney, just put NA. So I'll complete that. And then we go down to the third line as well. So remember, our succession is about getting this concept for our clients. And generally, once they do this, it's going to mirror what will happen for an SMSF will if they're doing leading members, and also if you're doing a trust around leading member appointors, and also executors as well. So we're getting this good succession flow coming through. Now, attorney for what? Choose which area you would like your attorney to act for you for. That's probably better. They hold complete power unless you provide terms and conditions, and for financial or acting as your super trustee, you must also choose when the attorney power is a start. So financial, this provides your attorney with the power to sign contracts for your sale, property shares, manage your accounts, do all things financial. Are there any conditions or terms? So we put in there, I don't want them to do whatever. When is the financial attorney to start? Upon signing, which is the preferable because they can act as trustee, when I'm no longer able to make decisions for myself. Superannuation, this provides your attorney. Now, if you go through our system, you actually have to tick boxes. So there's two powers of attorney in the financial. There's general financial, and then there's superannuation. So again, they put that in, and when's it going to start? So we'll put that in. Health and illness, this provides your attorney with the power to make decisions. So it should be for your healthcare in the event of illness. They may be the same as a financial attorney, it may be a different person. If they are different to your financial attorney, place their names below, but if not, just say NA. Their commencement arises at the time of you no longer be capable. So it's not like this one where you can sign upon it. So who is it going to be? If not, then just non-applicable. So that applies to the original one. And are there any conditions or terms? Now, generally, we don't want to do, there's a difference between someone looking after your health versus what we call an advanced healthcare directive. Advanced healthcare directive is like, for example, turn my machine off or don't look after me, whatever. So I've just gone through that with Mum, and essentially that will be a separate document, but we'll be bringing that out a little bit later, probably I think it's around about May when we do our roadshow, when we look at our living will. And a living will is a set of directions as to what the trustee of the super fund, and we can also do the same if we wanted to in a trust, on how they should be looking after you in one way, shape or form. Now, part of that, there will also be an advanced healthcare directive. So that's a big thing coming for us at the moment. We want to do our EPOAs. So that's our EPOA letter. Again, I can see there's a few typos. I only did it late last night. We've put it up just so you can have a look. If you like it, support at lightyeardocs.com.au. We'll send you the letter, and if you could then just mark it up. So the way you do that is you just go review, and then you track changes. So just track changes if you want to make changes. That way I can see what they are. So let me just go off there. So no longer tracking changes. So that's the enduring power of attorney. And from that, we can fill in all of this data that's coming through, financial matters, if we have a look there. So act on behalf of super, do anything. So you can actually see all of this fits in really easily, and we can complete it pretty quickly once we get that data capture. So the idea of the letter is to go beyond the engagement, but also getting the data in. So virtually it's a fait accompli. So they don't even need to do an appointment, just come through the process. So you might just want to tweak the letter, come in for an appointment, or alternatively, come in for an appointment and bring your data capture in with you. So you can virtually do it on the spot if they wanted to do that. So let's go through and have a look at our next one, which is I'll go back to our advice toolkits. As I said before, this will and client fact find, I'll go and reboot that, and I'll put the letter in for us as well. So I'll show you the Will and Testamentary Trust. I'm quite proud of this one. So again, I'd love to have your feedback on this, and once I do this, I will be doing some client videos as well on it for you to send to your clients. So again, same thing. It's just a letter. Has a lot of stuff here. Now, so this letter has been designed to encourage clients to review and update their will to provide lineage or bloodline planning. So the focus here is a little bit different from typically what a lawyer would offer your clients. Again, they're transactional. They'll simply say, do you want this? Do you want that? Do you want a testamentary trust? With our process and system, you can build testamentary trust quite easily. So let me go through anyway, and probably it's not a bad idea for you guys to do one yourself. This may include a succession of executors, specific bequests, creation of testamentary trust on the death of the testator, payment of monies to an estimate and further options. Warning. As an advisor testator, you must be mindful of the various states' Legal Professions Act, as unlike superannuation, providing final legal documents evidencing a will may be seen to be the provision of legal advice. So you hear that all the time from guys like Dan Butler and a whole range of really old crotchety lawyers and QCs. So if you want, then there's a sign-off option there for you. You still complete everything. So you might be charging, like, for example, $2,500 for a will with testamentary trust. If you want it for a couple, then our fee is essentially you get it into a form, they fill the fact file, you get it in a form, send it in to us, and then we have a Zoom meeting. And if it's just one or it's two, if it's a couple, then we have a Zoom meeting, we go through the process, and then we go through the sign-off process. So again, then that would come out of the Abbott-Morley letterhead, obviously. So be recorded, so on and so forth. So this is what I put in. Will review and upgrade service now available. We're writing to all our clients on the importance of having, firstly, an updated will in the event that something happens to you, and secondly, one that provides as much protection as possible from a family provisions challenge. So you can see I'm starting to move down this track. You may not be aware that there are a wide range of relatives, including children, grandchildren, former spouses and partners, children's spouses and other eligible persons who may make a claim on your estate after your death if they've not been looked after or feel that if they have not been looked after by you in your will. Important. A family provision claim may result in long and costly court proceedings. In Western Australia in 2018, the judge of the WA Supreme Court castigated lawyers who had taken 5 years and $500,000 in legal fees to challenge a $600,000 estate. This is happening every day in Supreme Courts around Australia, so we do not want that to happen to you. If you want, I've actually got a link, so it's not a bad idea maybe to attach as an evidence. I think I've got that. It's a revenue. I've got an article here I can send to your page. It's from Perth Now around it. So it's not bad to attach that again from that process to this data capture. Now we're writing to let you know there's some exciting news. Some exciting news that to solve the above issues, we've teamed up with lawyers and specialist estate planning advisors Abbott-Morley to provide a wills and testamentary trust package which can be limited to your lineage or bloodline should you require. This will ensure your hard-built assets are kept in the hands of your lineage. Now, how many people want to keep their assets in the hand of their bloodline? Basically, everyone. So the process is simple and it's crucial to get your executorship right. The person who you nominate as your executor, and it may be more than one, are the persons who will look after your estate. Manage any of your specific bequests, such as property going to one or more family members, jewellery to grandchildren, well, anything you desire. They can also limit any disposition of your estate to your lineage, which is your direct descendants, or to bloodline only, which may include brothers and sisters, in the event that a main or specific beneficiary is alive. So the executor also has the power to create a trust on your death known as a testamentary trust, which can be a discretionary trust that has only beneficiaries being your lineage or bloodline. Further, testamentary trust can provide protection for a beneficiary from litigation and attack on the assets of the trust, a great asset protection structure, the tax advantage of the trust. Note, one of the most important roles for an executor is to fend off any family provisions challenges, which is why a strong and secure will with testamentary trust is required. In the event the prospective executor is not alive or does not want the position, you should have a second in line and also a third in line. We'll be there to help and guide them through the process upon your death. As your advisor, we strongly recommend that together we undertake a simple three-step process to implement your will with any testamentary trust if required. Complete the quick interview, attach, send to us. We can use as discussion points to draft your will. Review the documentation along with what happens to your superannuation and any other interests you may have. Have a meeting with lawyers from Abbott-Morley to check the will and witness execution of the will. Now we could, if you wanted this to go out and then come back, we can put our pricing in there. So we can provide the above three-step for blah and then blah. or you believe it is important to complete an updated will immediately to provide stability, certainty, security. So if you don't want to do that, if you'd rather get to the appointment because it's a high ticket thing, just take that out and then just say, we believe it's important. So cancel. Don't know what's going on there. So we can just simply take that out. We believe it's important to complete an updated will, blah, blah, blah. Due to how close the age, we can turn around the documentation. Please know we like to go ahead, or happy to think, so that we, go ahead, so we can book an appointment with and go through the attached interview with you. So if you want to do that, you can either bring them in and go through that as well. That's not a bad idea, because then you could actually do the EPOA and the will at the same time if you wanted to do that. Alternatively, you could just put the pricing in there. It's up to you. So we're giving you plenty of opportunities. So here's the data capture. Who's to be, so as you can see, it's very much like the EPOA. Who's to be your executor? In the event that executor is not like blah, 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 blah. So you can see it's very much. Now, this is important because the way we've drafted the, if I go and take you up here, so I've got the moat here, and I'll go back to the documents. I haven't chosen, I've gone the upgrade. So let's say I'm just going to go straight through to the will. Then up will pop all the will. So you've got the executors, the successor executors, estate beneficiaries. So it could be, for example, the spouse, is she a main beneficiary? Yes. But generally specific bequests. So you can see here there's a specific bequest. Who's going to shoulder expenses? It's the estate. And then we go through the specific bequest. So into the estate beneficiary. So that would be, we can, obviously I haven't put anything in there. So if I put all the beneficiaries here, then what we do is that's a drop-down box, but I haven't done that. So essentially it flows through, and here, specific bequest. Do you want to make a specific bequest to any person, such as my investment property 5 Smith Street is go equally to my 3 bloodline children? Or my sister Joni Smith is to receive 100,000, or all my estates to go to my wife Janelle. Feel free to make as many bequests you want. The more specific bequests you make and provide for the lesser chance of any, that provides for the lesser chance of any challenge, it makes the role of executor that much easier and faster. So specific bequests, this provides your executor with the authority to transfer property, shares, jewellery, cash, or a percentage of all of your assets after any specific request to a certain person or group of persons. Please be as specific as possible to identify the assets and persons, which may include a charity. It does not have to be only persons or charities resident in Australia. So we've got specific request number 1, and then you can put T's and C's. So for example, it could be my investment property provided they are married still or whatever. Bequest number 2. So I've gone up to 6 there, I think. Now, that should get down the track. My preference is, look, you could just say it's main estate, and all, even if it's just the spouse, you could just simply put in there specific requests, all of my assets to go to my spouse. That's it. So you can simply do that. That's called a simple will. So then you go through that process. They don't want anything anymore. Now, when we do here, testamentary trust, you can provide in your will for your executor along with a specific beneficiary transfer part or all their specific bequest to a testamentary trust where the beneficiary is the trustee unless they are under age 21, where the executor will act as trustee, blah, blah, blah. Please complete the following. I would like the executor to create testamentary trust to protect assets from my bloodline. Now they're built in anyway. So every time you do a specific bequest, effectively you can get a testamentary trust. So they might say, look, I only want to do it for 3. Then that's part of your discussions with them. And then they can put in here the age, any beneficiary, and they might put in there like 35, for example, if they want to do that. Now, after all the specific bequests of funeral expenses, etc., anything left over is called the residual estate. So who are the main beneficiaries, which follows on from our system here. So I've got, is it a main beneficiary? So we put that in there. So who are the main beneficiaries? If they're not alive, who's the next person? And if the second line's not alive, who's the next person to get it then? And then once you've done that, one thing I haven't put in there is, for example, a life interest, which is, I might need to update that. That's for example, if there's a property and they want the spouse to limit it for their life, then effectively I'll have to put that in there as well. But essentially that's our data capture, and also for our will. I will do the same thing for, I'll go down the track and do the same one here for our SMSF will client fact find. I'd like you to give me some feedback on these two first, such that then we can do the will and client fact find. We can then go through and we'll do a leading member as well, so we can start to put it together, and then we might even do a complete moat. But my preference is you don't want to overwhelm the client with everything. Stick to a process and say, look, you can virtually do everything if you wanted to by going through that whole process, all those documents. But what we want to do is do the enduring power of attorney, maybe the wills and testamentary trust, then go and start to focus in on the superannuation side of things. And of course, you can always go through the process of doing a variation later on when it comes around to the family trust. And I'll show you what's coming on down the track. But essentially, if you'd like to have a look at those, please feel free to contact us feel free to contact us at support at lightyeardocs.com.au. So as I said, they're in draft. They will be finalised, but I need review and comment, so that it should be early. We're basically following the moat strategy automation. Instead of doing separate documents each, we can actually build it all into the moat itself. So that way, for each family, you've got essentially one moat. Now, again, it's good to have these, but now they're documents. Let's get them finalised and send them out to the clients to see what the feedback is. We could do it in an email. We could do it again by post, or we could do it both, so that they can see that we're really keen on them. So what's coming? Just a couple of things. We'll release that finally. For those of you who are strategist members on I Love SMSF or LYD strategists, I did a pretty advanced strategy session yesterday on income streams, where we went through the legislation, ATO guidelines, and started to look at a case study with a second spouse, wanting to also keep the spouse potentially open to family provisions challenges. I'll be following that up next Wednesday, 12th of February 2020. Now, this is an exciting one. The Protector, which is essentially a very advanced, well, it's not actually that advanced strategy, but its import is to provide asset protection for clients. You're going to love that. Again, it's an automation that we've built. That'll be up and running. Normally it'll be on the 13th, our Thursday session, but I'm actually doing some training in Sydney with a pretty large accounting firm on that day, one of our licensees. So we'll be releasing that 11th of February 2020 at 10 a.m. So make sure you come along to that. To simply come along to that one, you just need to go to the front page of LightYear Docs. In fact, if I just go there, so just go to the front page, click on that, register for our next webinar, which will hopefully come up, that's today. So that will now pop into after today, that will go to the 11th. So watch that one. The other one is if you are looking at going to the 23rd and 24th, let me just go on I Love SMSF. There's still a couple of tickets left. So I Love SMSF Home. You've got here our accreditation and succession estate planning conference. There's only 2 tickets left. I've only got a room of 35. Beautiful area there. What we will be doing though is we effectively will be videotaping that. So if you can't make it, those videos will be available shortly thereafter, about a week or 2 after that. So again, you'll be able to get CPD and all that. Anyway, that's enough for me. If there's any questions, please send them through. I'd love your feedback on those letters. And once we get that down pat, I'm going to start working through a lot of our strategies, for example, the SMSF loan, such and such, so that you'd be able to go to the SMSF loan, for example, is where an SMSF, whether the parents or the grandparents, can lend to a family trust or to a family or bucket company, and charge market rates of interest, and just don't go above the 5% rule. So again, that's not a bad stuff to send out to your clients and get some feedback, just to show that you're on top of the strategy, you get all the relevant information, the data, and then you can start to move on, so that really it's a complete done for you. The strategy is there, you understand it, the client engagement, you get the data in, complete it, have a meeting with the client, and then you're off and running. So our whole goal is to make your business as successful as possible, knowing that really a lot of you are tied up with compliance. Either you're a planner or you're an accountant, you're tied up with compliance one way or shape or form. We're trying to take that off you. One of the ones we are looking at, which I think is very exciting coming down the track, is we've got a whole lot of SOAs coming, but we've also got another system whereby we can build, for example, a de facto website for you. So it doesn't impinge on your site. It can just be a link from your site to this. It'll be badged in your name and also your colours. But what it'll enable us to do is actually put information through on that and start to build that site there for you. So it means it'll continually be updated with videos, information, so on and so forth. So it's a great little infotainment site that you'll have complete access to. But anyway, that's something that's going to be coming down the second half of the year if we get it right. But look, at this point in time, let's do it the old school way, get those engagement letters out, the fact finds, and start to really look after our clients for things that are important to them. I can tell you, bloodline, keeping money in their bloodline is absolutely crucial for them. Anyway, it's Grant Abbott signing off.